Now, that's all I have to say. I'm going to hand it over to Alma. She is a partner in the Trusts and Estate Group at Lakin Spears LLP and is certified by the State Board of Legalization or of Legal Specialization as a specialist in estate planning, trust, and probate law. Hope I got that all right. Alma, it's all yours.
Okay, so hello and welcome. As Andrew mentioned, I'm Alma Soongi Beck, and I've been practicing in trust and estates for about 20 years. Before that, I spent a couple years doing labor and employment law. I got into trust and estates because mostly I wanted to serve our community, the LGBTQ community, and also unmarried couples. So I do work with all sorts of couples and single people and families. And I have a particular sweet spot around unmarried and same-sex couples. So I'm happy to be here to talk about a little bit. We only have a little bit of time about some of the special estate planning issues impacting the GLBT community. So I'm going to start with sharing my screen, and I have a PowerPoint presentation. There will be no way I could go through all of the PowerPoint slides, but I will do my best to get to the important ones. All right, so here's me. My law firm's Lakin Spears. We're based in Palo Alto. I have a satellite office in San Francisco. We are actually only meeting remotely right now, except in very rare situations. And that is how to reach us. This is a little bit about my practice. I basically do estate planning and estate and trust administration. And we have a whole trust and estates team at Lakin Spears. We have 4 partners and 2 associates and some paralegals. Estate planning is what we're going to focus on today, which is the documents that we do in advance to help in the event of incapacity or passing away. And estate and trust administration is what we do after someone has passed away when you're trying to settle someone's estate and all of the things you need to do to settle the estate and deal with debts, taxes, and expenses. So we're going to refer to that in the talk today, but we're not going to focus on that today. These other 3 things on here, Medi-Cal planning, domestic partner registration and federal tax issues, and property co-ownership issues, these are mostly subcategories of estate planning. And we will be touching upon them to a small degree, more on domestic partnership and property co-ownership, less on Medi-Cal. Medi-Cal is its whole other talk. It gets very complicated. It usually affects people over 70 who are in need of long-term skilled nursing that would be covered by Medi-Cal. Domestic partnership and marriage is something that we consult with people a lot because in planning for LGBTQ folks and for unmarried couples, there's a big question that comes up about whether we should get domestic partnered or whether we should get married, and how does it impact our estate planning? And also, what does it mean that we got domestic partnered or married before, and in this order or in that order, or did this get repealed or did that get repealed? So we are going to touch upon that today as well. And then the property co-ownership issues when there's a couple that owns property together and they're not married and they're not domestic partnered and they choose that not to do it over the next period, there's some very particular issues about co-ownership and property taxes. So we are going to touch upon that at the end. All right, so that's the little basic agenda, but here's the specifics. We're going to talk in 5 sections. The first is just the basics of estate planning, what it is and the basics of how it works. The second is some special healthcare directive issues that come up particularly in the LGBTQ community. Then we're going to talk about marriage and domestic partnership, as I mentioned earlier. We're going to talk about this fun concept called transmutation for people who are married or domestic partnered. It has a huge impact on people's capital gains. So just kind of hold on to that until we get there. And then the last is the property issues for unmarried non-SRDPs. SRDP is an abbreviation I use for state registered or state recognized domestic partners. All right, so let's start with the basics. As I mentioned earlier, basically what we're doing with estate planning is we're planning in the event of incapacity and in the event of passing away. Most people that come in for planning come in because they're trying to figure out their financial planning, and they're also trying to figure out how to protect their partners and their families and their spouses and their kids and whatnot. And so, you know, one of the things that people think about sometimes when they come in, they're like, well, you know, if I pass away in 20 years or in 30 years, but I often will encourage people to think about your planning as if something might unexpectedly and prematurely happen in the next 3 to 5 years. And then review your documents every 3 to 5 years. So even if you've done documents, but it's been more than 5 years since you reviewed it, you should pull it out from where you kept it and look at it and see, does it look like it's still appropriate to your situation? And even if it looks appropriate, still call your estate attorney and see if you can arrange a consultation to talk about what's changed in the law that might actually impact how your planning is done. So around incapacity, there's two main things that we're planning for. The first thing is health. The second thing is finances. Who's going to take care of me if I can no longer decide for myself or communicate? Who's going to take care of my finances? And if I am a parent of minor children, who's going to take care of the finances that impact the minor children? The second thing is about passing away, which is who's going to get my stuff and who's going to be in charge of settling everything. So I've already talked about the two documents for incapacity. The document is actually called the Advanced Healthcare Directive, as it says on the slide. And what you do in the Healthcare Directive is it's a fairly short form that we have in California. You can usually get it from your doctor or your medical provider. You can often get it online. And you want to use the California form, but it's usually only about 5 pages. And if you get it from your doctor, maybe it'll be longer because there'll be blanks for things. And you appoint who are the right people to make your healthcare decisions if you can't. And I just want to kind of point out that you don't have to have just one person do it. You could have more than one person do it. Maybe it's, okay, there was a point when maybe someone's partner might not be comfortable with medical decisions. So maybe you have a sibling and your partner do it together, but you can always update it if you want to change it, if things change. Okay, same thing with the power of attorney for finances. You're basically giving people the power to manage everything. So if I suddenly became incapacitated, I would want someone who can check my bank accounts and make sure the bills are paid and check on all of kind of my other like life insurance policies and just handle everything that I handle on a day-to-day basis regarding my finances. So that skill set is different from the healthcare directive. Sometimes you name the same people, but you can name different people. The last thing I want to mention is it's good to name one person to do it, but I often will recommend that people name at least 1 or 2 backup people, because what if something happens to you and that first person? Because you want the documents, like I said, to last 3 to 5 years. And if you're going to an attorney, it will help keep your fees down if you think forward maybe 3 to 5 years of like, okay, if this person can't do it, then I have backups. The other thing I wanted to say about agents for healthcare and power of attorney is that you might not have people you feel comfortable in your family making those decisions, or you might not have friends that are local or that you feel comfortable making your financial management decisions. So there are people who do this job called private professional fiduciary. And fiduciary is an umbrella term that refers to anybody that has some kind of legal obligation to take care of something, like healthcare decisions or financial decisions, or be executor of your estate. So you can actually shop around for them. And if you do shop around for a private professional fiduciary, my suggestion is to talk to your attorney about it, because just like in any field, there's a variety of experiences and skill sets, and also you want to work with somebody who has a really strong track record. So there's a variation of that. Just like when you're looking for an attorney, you want to get a warm lead or a good referral, or make sure that you vet people. So same thing with private professional fiduciaries. Okay, so those are those 2 documents. I often will say, and this is the reason I talk about it first also, is that these are the 2 most important. I do think your will is important. I think your living trust is important, but these are the 2 that are going to affect you while you're alive. So there's sometimes people say, I don't need an estate plan because I don't have any money. But you do have a body and you do have health needs, so you should at the very least get a healthcare directive. And even if you feel like you don't have any money, there are financial transactions you make. Like someone is going to have to figure out like the deposit of your paycheck or the receipt of your Social Security benefits or paying taxes or things like that. So these are fairly easy documents to do. When you do them with a lawyer, they're not that expensive because it doesn't take a lot of time. And your healthcare directive, you can often do on your own as long as you know how to answer the questions. The power of attorney is one that I do recommend that people at least consult an attorney about. My issue with the power of attorney is that it's almost too easy to do on your own. And what you're doing is giving people broad financial powers, including the power to completely empty your bank account. So you want to be really thoughtful about who the people are and whether you want to name it private, professional, or whatnot. All right, now we're going to talk about passing away. So you notice that I have 3 things listed here, and wills are on the bottom. That's because before they look at the will, they look at the beneficiary designations on your accounts and your policies. So the beneficiary designations go first before your will gets looked at. And if you don't have a will, the probate code has a whole series of based on people's relationship to you, who inherits and in what proportions. So you want to really pay attention to what your beneficiary designations are. When you have retirement accounts, like tax-deferred retirement accounts, IRAs, 401ks, 403bs, whatnot, you are often required to name a beneficiary when you set it up. And of course, when you set it up, there's usually nothing in it. So you may not remember who you named as your beneficiary for your 401k that's now $100,000 or $500,000 or $1 million. And if you don't remember, you should check, because it might be your ex, or the ex before that ex, or the family member that passed away, or the family member you don't talk to. So that is crucial. The other thing I want to say about beneficiary designations is, not everyone knows this, but bank accounts do not require beneficiaries, but you can put them on those accounts. They're called something different, but you go to your bank and you say, hey, I have a checking account. Can I name a beneficiary? And they'll give you a form. It's usually called pay on death or transfer on death form. But basically, you can name a beneficiary for your bank accounts as well. So I still recommend that you have a will, because there are going to be certain assets you can't name beneficiaries for. And also, you don't always want to rely just on the beneficiaries, because if you rely on the beneficiaries, it might create other problems. Like if all you have are accounts and life insurance and you've named beneficiaries, then where's the money going to come from to pay for the cremation and burial and funeral and final expenses and whatnot? So often when people come in and everything has beneficiaries on it, I will sometimes recommend taking some of those designations off and relying on a trust or a will. So this is why it's good to at least consult with an attorney about it. Okay, so that's beneficiary designations. The second thing on this list is joint tenancy and joint accounts. So you may have joint accounts with a spouse or a partner or a sibling or a family member or a parent or whatnot. When you have joint accounts or property that you own in joint tenancy or joint tenancy with right of survivorship, that automatically transfers to the other owner or owners when you pass away. Now, for a lot of couples, this is exactly the result they want. So they're like, okay, we bought this property together. We're together as a couple. If I pass away, you get the property. It's not always the right situation for all couples that co-own property. And the other thing about joint tenancy, it is by definition equal if it's real property. So you just want to make sure you understand what it is and that it's actually what you want. So joint tenancy is often a good result. There's other problems with it, which we won't have too much time to touch into. But one of the problems is if you have a very large estate and you have a lot of joint tenancy property and you're not married to each other, it could end up getting double counted in a way for purposes of calculating estate taxes when you pass away. That's just an example. I'm not going to go into it too much because of time today. Okay, so now we're at wills. So anything that doesn't have a beneficiary, that isn't joint tenancy or joint account, it's going to go under your will. Oh, there's one more thing I need to say about joint accounts. I will often get people that say things like, so they come in and they say, fill out the intake form, and I say, oh, there's this bank account. It looks like it's a joint account with so-and-so. Sometimes it's the partner or spouse. Sometimes it's a parent or friend or ex or somebody. And then I'll ask, so why is it a joint account? And they'll say, oh, well, if something happens to me, I want this person to manage the account. That's usually when I say, that's probably not the best way to do it. It's probably better to put them on as your power of attorney to manage it if something happens to you. unless you really want them to inherit the entire account when you pass away. And I'll sometimes have parents say, oh, well, you know, I have 3 kids and this is the responsible one and they're going to help me with finances and they help me pay bills. And then I'm like, you can give them signing powers. But if that is your main account, then it's all going to go to that one kid. And guess what? Everyone else is going to start fighting them about it later when you pass away. Okay, so that was just kind of a little caveat and warning about joint accounts. All right, so now we're going to talk about wills. Wills are basically what you expect them to be. It's a document that says who gets what, and it's a document where you nominate an executor. The executor is the person who manages that process. So there's who manages it and there's who gets what. Don't get them confused, because the people that get it aren't necessarily the people you want to manage the process, and vice versa. And then there's, if you have minor children, the will is where you nominate guardians. Now, notice how I said nominate and not appoint. Nominate is the court appoints the guardians based on the best interest of the child. But if you're the parent, or like you're the surviving parent and you've nominated certain people as guardians, they're going to give very heavy weight to that, although people can come in and try to argue that maybe they're not the best guardians. Okay, so that's those documents. So now we're going to talk about revocable living trusts. So why do people have revocable living trusts, and what are they? Well, the 2 main reasons why people have revocable living trusts are listed here. One is to try to stay out of court. The other one is to create protections for other people. So how do you stay out of court? You may have heard this term avoiding probate, and probate is shorthand for the probate court supervised proceeding. So if somebody has, and we're not talking about, you know, joint accounts, those automatically go to people, joint tenancy go to people, beneficiary designations go to beneficiaries. So these are the things that don't have those things. And so if it's over 166,000, I should have wrote that on here, but 166,250, that's what triggers a court supervised probate proceeding. Or real property, house, land, timeshare interests, in some cases, condos, if it's worth over 66,000. I think it's 66,000. Something like 50 to 60,000. I'm sorry, I don't remember the exact number off the top of my head. Of course, anything that you could live in that you're on title for would be definitely worth over that anywhere in the San Francisco Bay Area. There are very rare cases, like with timeshares, as I mentioned, also land, like vacant land that don't have roads, or very, very small partial interests, where that we don't need a full probate proceeding to get it transferred to the next people. Okay, so why do we want to avoid probate? Well, have you tried going to court these days? We're in a big pandemic where the courts have limited staff. They have very little that they're doing in person. So this is an example of, as soon as you get to court, you're at the whim of whatever's going on with the court. So we're having an issue right now, but even before this whole stay in place order, we had issues with the court, and the issue was the judges would change every couple years. There's some counties where it would be like, you know, a much harder process and a much easier process in other counties. Right, like for example, right now, a lot of attorneys really like San Mateo County to bring proceedings in where they possibly can, but that could change. And when I've noticed that sometimes when there's new judges, things take longer because they're trying to get used to how to run the court. So anyway, I do whatever I can to try to avoid the court, and I think you should too. All right, the second reason, why else do you set up trusts? What you can do in a trust is you can create protections for other people for what you leave to them. So your partner or spouse, your children, sometimes if they're under 18, but also over 18. Older children, and anybody that's on public benefits like SSI or Medi-Cal. If you are leaving anything to anyone on needs-based public benefits like SSI or Medi-Cal, you really, really should set up a trust so that you can leave what you're, even if it's a really small amount, because to qualify for these public benefits under current law, you have to have less than 2,000 of countable assets. They don't count things like your primary residence and your first car and your tangible property, and so, in many cases, your IRAs. But if you're getting something from someone else and it's over 2,000, it's going to disqualify you from Medi-Cal and from SSI benefits. Okay, so I want to get back to young children for a minute. The thing about young children is if you don't have a trust, then typically everything will default to go to your kids when they're 18. Well, they get it even if they're below 18, but there's a guardian appointed for the estate to manage the estate. And then as soon as they turn 18, guess what? They get to manage everything. So if you're a parent and you maybe don't like the idea of your 18-year-old child managing the entire estate or even getting a hold of even $10,000, that would be an excellent reason to consider setting up a trust. What we do in trust often for parents is we'll say the kid can be co-trustee with an older person that they trust at a younger age. So maybe like you get to be co-trustee at 25, but at 30 you get to be full trustee, and being full trustee is the point where you get to actually manage it on your own. So you get to think about that as a parent. I'm going to go backwards again to partners and spouses. There are really crucial creditor protections that you can leave to your partners and spouses, but really to anyone that inherits from you. And so these are the two that come up for partners and spouses, which is creditors and the pool boy or pool girl. So the creditor issue is you pass away. So let's say there's like $1 million, because the math is easy, and $500,000 belongs to each of you, and you leave your $500,000 directly to your partner or spouse. So if you do that, then if they later get into some kind of liability issue, car accident, unexpected lawsuit, whatnot, everything, all $1 million is accessible in that action. However, if you have left your $500,000 to your partner or spouse in a trust, and you can set it up in ways where they have a lot of control, you can set it up in ways where they can have an independent trustee to make full distributions to them, then it's much harder for those creditors to get to it because it never really belonged to them. It always belonged to the trust. So those are examples of when you might want to think about setting up a trust. And sometimes people are like, oh, we don't have any creditors. And it's like, no, the issue is not whether you have creditors now. You might have no worries that they're going to pay their bills, although it can happen that people can suddenly be in a position where they can't pay their bills. But the issue is actually the unexpected thing that happens, like the car accident where the liability exposure is beyond what you have coverage for instance. So I just want to kind of put that in people's minds. And then I'm going to talk for a second about the pool boy, pool girl clause. I like to call it some assurance things will go back. So one approach is you could say, I'm going to leave you my $500,000. And if you meet the pool girl or the pool boy, that's fine. Go ahead and use my money for that. If you want to change who it goes to, then it's okay. It doesn't have to go to my beneficiaries. But if there's any part of your mind where you're like, you know what, go ahead. If you're going to meet the pool girl or pool boy, go have fun with your part of the money. And you can use my part of the money for what you need it for, but I don't want you giving it away to other people. I want you giving it back to my family or my beneficiaries or my charities when you later pass away. So that's another example of how you can use a trust to kind of like meet your wishes. All right, I think that's it for that slide. So let me move on. All right, so I want to say a few more things. This next one is about options under the shelter in place during COVID-19 pandemic. So I and a number of people in our firm have been extra cautious about really, our procedures were very kind of like face-to-face meetings. And then when we signed documents, like we would have our secretaries and us physically present in the room to sign those. And of course, we're much more concerned because of the potential exposure, and also because we have so many health compromised people in the LGBTQ community. So we started really looking into mobile notarization. So mobile notarization, the advantage of that is a lot of them have really upped their safety protocols because they are allowed to notarize and they are considered essential workers. But they're doing it, so they're taking extra precautions. So that's what we're seeing. But the other thing that not everyone knows is there's this thing called remote online notarization. California notaries are not allowed to do this, but other states have had this for a number of years, and California is clear that it accepts notarizations that are valid in the other states where it's performed. So this is sometimes an option for people. It's less tested, but what we found is the counties are accepting remote online notarized deeds, and they're also e-recording them. So that's where we have on the bottom e-recording, because if you have a remote online notarized deed, the original is the digital copy. So you actually cannot physically record that deed because you have to print it out and that becomes a copy. So it only works with deeds if you actually e-record them. And I wrote My Legal Depot because they're actually the best vendor that we found to actually e-record. It was actually very difficult. It took several months to find a vendor that was willing to e-record deeds. So if you want to referral for remote online notaries that we've had success with, I suggest finding a person or persons. There are some websites that do it. We tried notarize.com. I hated it. I had to be on the phone, like on wait for like an hour, sometimes 2 hours. And it's not certain enough to really be able to schedule clients. Okay, the other thing is about wills. Wills are, if the wills are handwritten completely in your hand, they don't need witnesses. Now, when we draft wills, we draft them several pages, so that's a lot to be handwriting. So what we will often do is we'll do the regular version of the will, and then we'll do a very condensed one that has the essential items that people need to do, and then they handwrite that. Even so, it's like 1 or 2 pages, and then I have clients that say, you know, I haven't written anything by hand as long as this for years. So I got a hand cramp while I was doing it. But that's how it works. It's like if the whole thing is in your handwriting, you don't actually need witnesses. And then we have this issue with like, okay, well, what about the longer will that's typewritten? There is a requirement in California that you have 2 witnesses who are present at the same time. Or you can show by clear and convincing evidence that it was your intent to have that will. But that second standard, that's a newer one. That second standard requires you have to be in a situation where you're needing to prove it. And what you really want to do with your estate documents is you want them to kind of be as self-proving as possible, because you want to minimize challenges where you actually have to prove it in a court. So there's unfortunately no case law that we found on the validity of video witnessing. There's a strong argument that you should be considered valid because you're there in person. Is it present? Am I present with you now? I'm sitting in your living room on a video screen. And if this was like it's like a 2-way conversation, would that be present at the same time? So there are questions with it. So we are relying on the handwritten wills, but we also are doing a longer typewritten one that has more of the bells and whistles on it. Okay, so that's what I want to say about shelter-in-place estate planning documents. All right, a couple more things. Oh, I already gave you the answer. I want to talk about parentage and I want to talk about gender. Parentage. How many parents can you have? And you already saw the answer, more than 2. But this is actually pretty recent. This law took effect in 2014. This actually was much thanks to the LGBTQ parent community, because many of our families actually create families in ways that are not just like 2 parents. So now you can legally be a 3rd parent or have a 3rd parent. So who is legally a parent? Natural parents and adoptive parents. Please do what you can to avoid the word biological parents, because it is not legally binding in either way. And I think it's confusing. And it's also kind of offensive if you're not actually like biologically related and it has all this like baggage on it. But the law looks at it, natural parents and adoptive parents. And of course, what is a natural parent? A natural parent is a parent who's not adoptive. So that's kind of circular. But sometimes when I'll do a longer version of this presentation, I have like 3 or 4 more slides on parentage. And I mostly want to flag this to people because there is a way you can be deemed a parent where you didn't give birth or adopt the child. And there's all these other ways. It's fairly complicated, which is why there's several more slides. But the point is that now I ask people, is there someone else that you raised that you put out as your child that might be deemed your child? Or is there anyone else your parents raised that might be deemed their child? Or is there anyone else who put you out as their child? Because these are all like, oh, maybe that person would be considered your parent or your sibling or your child. And then I do a general disinheritance clause to the extent I can that just generally names who the children, parents, and siblings are, and that anyone else claiming that relationship is intentionally disinherited. So these are things to think about because I think you don't want to just assume that people are only going to have two parents now. All right, gender identity. Why is this important in an estate plan? So it comes up around name usage. Sometimes people will come in after they have made a legal name change and want to take the previous name out. And as folks know in the community, you know, when people are, some people kind of sit in the non-binary spot and might use different pronouns, but at some, and there's actually a third gender, I think it's permitted in California, but definitely in many states in the country. So that gender pronoun is not as important legally. What's important is people's names. And the other thing is the notary block needs to match the driver's license or the ID that's used. So sometimes it's not just with people who are TGNC that have this issue, but like anybody who might have a different name on their passport versus on their driver's license. So I will always ask, what is the name? How exactly does your name appear on your driver's license so that our notary block matches it? And is your passport name different? This will sometimes happen like as people get married of any gender where they might change part of the name or hyphenate it or whatnot. So that's just something to keep in mind. And then I have a couple more things. Oh, health records. So I do have some trans clients who like some of the health records still have the previous name, but all of their other identity documents have the current name. And so you just need to kind of think about it as you do your documents. Like you just want people to be able to identify where your records are. But oftentimes if people make a full transition to a different gender identity on their forms and on their legal documents, the health records will also reflect it. So just kind of think about it on a case-by-case basis and in your particular case. And then, oh, I mentioned this already, that some people will actually change their documents. But if people's IDs still have the previous name that they only use on their driver's license, we still have to put it in the notary block. All right, gender pronouns. So this one is easy in terms of, well, just ask people the gender pronouns they use or use the ones they ask you to use. There was a point in time where the legal gender was important. Back in the old days, 5, 10 years, 20 years ago, where only opposite sex couples could get married. Knowing what people's legal gender was crucial to determine whether people could get married or not. That's no longer an issue since 2013 in California with the Windsor versus United States court decision. And then until this year, it was important for domestic partnership. But I don't know if folks have heard, now any couple, regardless of your gender, as long as you're otherwise eligible to get married, can get domestic partnered. So this is the game change. I mean, I think for the LGBTQ community, it's similar how it was, but for straight cis folks, it's like a game changer because what's happening is my straight cis clients are coming in and I'm saying, you know, they're saying, oh, I'm going to get married. And then I'll say things like, oh, did you know you could get domestic partnered instead of getting married? And then they're like, what is that? And then we talk about what it is. But basically what it is now is the domestic partnership is state recognition of marital rights and responsibilities, but not federal. And in a lot of cases, if both people are working, it's actually a better income tax result, but I send people to their CPAs to do that analysis. So I'm just flagging it for people that at least for domestic partnership and marriage, it's not relevant. And so the only place we're really seeing it is sometimes people want to put extra language in their healthcare directives if their kind of gender marker on their IDs or on their health records might not match their actual gender identity or presentation. So like sometimes we'll put extra language about hair, clothing, hormones, name usage, whatnot in the healthcare directive. All right. I'm not going to get through that many of these slides because I want to save time for questions. Second, we're going to talk more about healthcare directive language. So for the LGBTQ community, sometimes I will put extra language on who has right of visitation. And sometimes I'll say that, like, particularly if people are not married and not domestic partnered with each other, but they want to make sure their partner has rights. And it might not just be partner, because we have all sorts of different kinds of relationships. So it might be like your partner and your closest friend, or maybe your ex, but you want to make sure you're clear about like who has right of visitation and maybe who doesn't. Like if you have next of kin that you wouldn't feel comfortable with visitation, or that you wouldn't feel comfortable making your medical decisions. These are excellent reasons to do a healthcare directive so you can be explicit in the document about it. Maintaining clothing or appearance, we mentioned that before. We also mentioned private professional fiduciaries, because you might not have someone you're comfortable making your healthcare decisions, or you might have one person but not a backup. So this is the name of the organization, the Professional Fiduciary Association of California. And you also have to get licensed now to be a private professional fiduciary. But my suggestion is not just do a cold search, to actually try to get a warm lead from an attorney who has experience working with specific fiduciaries. Copies or no copies. So we suggest that people give at least a copy of their healthcare directive to their physician, and to keep a copy of their healthcare directive in your suitcase, that if you ever travel again, once this pandemic is over, you carry with you when you're traveling. Even if you're in a country that might not necessarily recognize it, your healthcare directive has the important kind of crucial names and contact information of who should be contacted, so it's still useful. We also create a laminated card for people's wallets, and you can create your own. You can get it laminated or not. I have a healthcare directive. These are the people I've named and their phone numbers. This is my lawyer in case you need to reach them. This is my doctor in case you need to reach them. Things like that. And then you want to make sure to update the copies if you update the document. I generally say with copies, don't give copies of your documents except this: your healthcare directive to your doctor and a copy with you when you're traveling, and make sure to change those out if you update it. The reason is because you are much more likely to update this document before you ever need to use it. So then you have all these rogue, outdated copies of things that you gave to other people, and maybe you've changed your healthcare agent and you don't even talk to that person anymore, and God knows where they kept it. So it's better to have control over kind of like who has copies and originals, and you do want to tell people that you have the document. So that's the last recommendation, which is we recommend not giving copies of anything else, but tell people you have the documents: trustees, executors, guardians, agents, where you keep them, and how to reach your estate attorney if you have an estate attorney. All right, 3, domestic partnership and marriage. Let's see if I can do the 3-minute version of this. As we mentioned, Windsor versus United States was the big decision that impacted California, because California was already recognizing same-sex marriages. And then on the exact same day, 2 years later, Obergefell brought same-sex marriage to the rest of the country. And I just like to kind of remind folks that it's very historic that it was right during the Stonewall Uprising anniversary time. Now that we have marriage equality, aren't the issues the same for same-sex couples as for opposite-sex married couples? And the answer is sometimes, when the facts are the same, although in many cases the facts are not the same. And here are some of the differences. Well, first of all, marriage might not be marriage. A lot of people say they're married, but they might not have a marriage license, or they might be domestic partnered and not married. And also we're seeing, like in the LGBT community, we have this unbundling of marriage, because before we were allowed to get married, we would do ceremonies or get a house or have kids together, but we might not have a marriage license, but we might exchange rings. But we're finding this true among younger opposite sex couples as well. There's a lot more, there might be more folks that automatically decide that marriage is the thing, but I do consult with a number of like younger opposite sex couples that don't necessarily assume that legal marriage is what they want. And that's when we talk about domestic partnership. All right. Also, not everyone is in the position to be out at work, even in the SF Bay area. I had a client once, she came in and her employer was actually out of state, but she lived here. And when you are married, your employer has to know, because it's on all of the tax forms and all of the payroll taxes and whatnot. All right, so here's the issue with domestic partnership. There are different kinds of domestic partnership. The main one that I'm talking about is the state domestic partnership, but even people who are domestic partners don't always remember if it was the state. or maybe they sometimes remember it wrong. I actually have an attorney friend. She's not an estate attorney. She's an environmental attorney, but she came in and she was like, oh, we've been domestic partnered for X number of years. This was a while ago. And I actually had a list of people who had been registered that year because it used to be public record. And I was like, you're not on this list. You should call the Secretary of State to make sure. And then she found out that they weren't, but they'd been filing their taxes like they were domestic partnered for the last 3 years. So that created a different conversation about what to do about their taxes. And then they registered right away. But the important thing is you want to know which one it is, because it's the state recognized domestic partnership. That's the one that gives you state level benefits of marriage. The other ones only give you benefits to the extent that, like, for example, San Francisco has a city and county domestic partnership. The best people that get benefits there are people who are employees of the city and county, because then you get awesome retirement benefits for your domestic partner and awesome health benefits. And the qualifications for city and county domestic partnership are different than for the state one. So just keep that in mind. And so we're not going to have time to go through all of these slides, so I'm going to just jump through, but we are going to make this available to other people, and you're welcome to reach out if you have questions. These are just examples of where there's local domestic partnerships. This is the law I mentioned that took effect this year that made domestic partnership available to everyone regardless of gender. It used to only be same-sex couples that were otherwise eligible to be married, or opposite-sex couples 62 and older. So this is a big change for the straight folks. All right, this is important, is that the California Domestic Partnership recognizes similarly, substantially equivalent registrations from other states. And it varies vastly, but there's some people who might have gotten a civil union from Vermont, or who might have gotten domestic partnered in Washington, or might have gotten domestic partnered here or there. And there's one court case that is about New Jersey domestic partnership that said it wasn't equivalent at the time, but I actually think New Jersey domestic partnership evolved. And then a lot of those domestic partnerships went away after we got federal recognition of marriage. So the important thing here is just to know, it doesn't necessarily mean that you are registered in California. I'll give you an example. We had clients who had gotten married in the 90s in the Netherlands, because one of them was a citizen of the Netherlands. And when they first came to see us, it was before the court case that recognized domestic partnerships and that recognized marriages. And oh, I'm sorry, this is a marriage example. Then when we got recognition of marriages, they were suddenly retroactively married. So they, up until 2013, they weren't recognized as married, and then suddenly they became recognized as married retroactively back to the 90s. So that situation has also occurred with domestic partnerships. Okay, so do your research. I had tried to do research once for a presentation I did, and it was impossible to get anything more recent than 2015 online. So this is where you want to actually find an attorney in that state to do the research for you. And there is a national LGBT bar association. So that would be my recommendation, is to reach out or to ask your estate attorney if they know people in other states. There's also the LGBT Bar Association is an association of state and local associations, so they might be able to get you in touch with the local one. The SF Bay Area has the BALIF, Bay Area Lawyers for Individual Freedom. It was actually the first LGBTQ bar association, which is why the name sounds kind of closeted, because it was back in the old days when you didn't want to put gay or lesbian in the name of your org. All right, so we're in the last 13 minutes of our hour together. What should I say about transmutation in 2 or 3 minutes? Transmutation is a complicated concept. It is about community and separate property. So let me just say what community property is, and then I'll just flag why it's important, and then call your estate attorney. Community property is a marriage concept. There are 9 states that have it, and it basically means that after you get married, or domestic partnered, because as you know, domestic partnership has the same rights and responsibilities on the state level, in the state, domestic partnered, then any of your earnings from your labor are considered community, even if you put it in your own bank account. So if I'm earning $100 after I get married, I can put it in my own bank account, but 50 of it belongs to my spouse. So the important thing about community property is that there's a huge income tax capital gains disadvantage for a surviving spouse or a surviving domestic partner. And I flag this for people because there are many couples who bought their property before they got domestic partnered and before their marriage, because we were only allowed to get married starting in 2008, and it was only recognized federally in 2013. And if your property's from before that, it's probably not in community property, and it's probably not hard to put it in community property. The difference for the surviving spouse could be hundreds of thousands of dollars should they sell that property after you pass away. So I just want to flag that it's really a big deal. There's actually a series of articles that I gave to Andrew that is going to be made available to the people who attended this. And there's an article specifically on the transmutation issue. So I encourage you to take a look at it. All right, so I'm not going to go through this, and I'm getting a notice from Andrew, that we should move on. So what am I going to say? This is a whole description of why it saves you hundreds of thousands of dollars. So the last thing I'm going to say is, if you are not married or domestic partnered and you own property with someone who's your partner, or you live with someone and you're the only one on title, you should really, really talk to an attorney about doing a property co-ownership agreement and about the property tax issues. The property tax issue is a major issue because if property appreciates, which almost all property in the SF Bay area does, and if you bought it for a certain amount and when you pass away it's worth a different amount, the property tax is going to get reassessed to the new amount when you pass away, unless you fall under an exemption. Spouses and state domestic partners are exempt. There are some other very particular ways that if you're not married or domestic partnered, you can avoid reassessment, but they're very technical and you really should seek counsel for this. This itself is usually a 20-minute conversation. So the other thing about the property tax issue is this just goes through what the rules are and how obscure they are. So property agreement and property taxes, those are the two things you should talk to an attorney about. The property agreement really just affects like if you own it together and you're not married or domestic partner, you could get stuck in civil court fighting over a partition action. So doing an agreement actually helps you avoid problems later. So in sum, the crucial issues to remember: review your estate plan every 3 to 5 years. Trust, will, power of attorney, healthcare directive, and in some cases, irrevocable trusts. Or immediately upon diagnosis that could affect capacity, such as dementia. A diagnosis that you have early onset dementia or early onset Alzheimer's doesn't mean you don't have capacity, but it does probably mean you'll lose capacity soon. So if you need to get it reviewed, if you come in right away, sometimes you can still be able to do it with a determination that you still have capacity. And then we talked, this is about Medi-Cal planning. If you're over 60, you should go in and have your estate plan checked to make sure that it accounts for Medi-Cal. And Medi-Cal planning is for people who have assets like $500,000 to $2 million that might need to rely on Medi-Cal to pay for long-term skilled nursing. All right, so choose your agents and trustees carefully. We talked about that. Long-term care issues. All right, I'm done. I'm at the end of my presentation, Andrew. So this would be a good time if folks have questions.
Yeah, absolutely. Thank you so much, Alma. This was really informative. I learned a lot. It gave me lots of homework to do. So while we're waiting for some questions to come in, I have a question. Say hypothetically there was someone, early to mid 30s, single, living in San Francisco. Where should he start? What's like the most, assuming I have done none of this, what do you think is the first thing that I should be worried about?
I often will suggest that you at least schedule a consultation with a lawyer. Almost all lawyers, including us, will offer a certain amount of kind of complimentary consultation. We offer a complimentary half hour because that's usually enough to kind of figure out your situation of what we would recommend. And then the recommendations for someone in that situation are almost certainly going to be do your healthcare directive, do your power of attorney, and consider doing a will. But I recently had a conversation with someone in that situation, and that person decided not to do a will, but decided to do a handwritten will. Like they didn't hire us to do it. because it was pretty simple what they needed. And so we were able to just kind of have a conversation about that, and it ended up being a small representation.
Good. And if people are interested in sort of designating planned gifts, what's the best way to start doing that process? Is it to reach out to you directly or to an estate planning attorney? Or do you recommend they reach out to some of the organizations they want to support? For example, maybe the GLBT Historical Society.
For example, what a great example, Andrew. I'm such a huge fan of the Historical Society. I would say both could work. Like, you know, there's a conversation to have with the attorney about certain legal mechanics of it. And then there's particular ways we're talking with an organization. Sometimes organizations have particular resources available to help think about it. So for instance, often if people come to me, I'll say, well, if you have an IRA or a 401k, and it's not a Roth, then you haven't paid taxes on it, which means your beneficiary is going to pay taxes on it. So if you were thinking about making a gift to the Historical Society, you could just name them as your beneficiary, or name them as your beneficiary after your spouse or partner, for instance. And that's a pretty simple thing that you don't even need a lawyer to do that. You can do it on your own. But the reason I suggest people talk to their lawyer is it's also holistic. Like, you know, if you have different beneficiaries for all your different things, then it can be hard to keep track of and hard to be strategic about it. So just kind of keep that in mind, that it might be good to pull in your attorney at some point.
Yeah, that makes sense. Looks like you've got one question in the chat, or two of them. The first one from Richard: if I own property as a joint tenant, can each of us allocate our half to our beneficiaries?
The answer is you can, but it won't work. It's going to go to your, it either won't work or it's going to create a fight between the people you've put in your will and the person that's named as your joint tenancy beneficiary. This is something you really should talk to an attorney about, because there's all these different implications. So for instance, sometimes you want to be joint tenants because you want to inherit from each other, and you want to make sure you inherit from each other. Sometimes I'll have just one person in the couple come in and they're like, I want to make sure that it comes to me when they pass away. If you want to name other people, then you need to split the joint tenancy, but it actually puts you in a situation where you actually need to set up a trust for those separate interests. Otherwise, it's going to get stuck in court. So you want to do it strategically, and if you're on good terms with your co-owner, then come and do it together, is my suggestion.
Okay. Don't try and go it alone, is what you're saying. Get an expert.
So we have a second question. If someone has a net worth of $500,000 or so, how do they get on Medi-Cal? That's not their home. Oh, okay. So this is where, gosh, at some point we should do a whole separate Medi-Cal planning program. But we have a very unique law in California around qualifying for Medi-Cal. And it actually depends partly on what kind of Medi-Cal. Like if it's under 65 Medi-Cal, I call that the Affordable Care Act Medi-Cal, for just kind of like your regular health insurance. That is actually income contingent. So your property is not relevant. But if it's traditional Medi-Cal, that's for 65 and older, and that's asset-based. That's the one, 65 and older is the one that impacts long-term skilled nursing. And, you know, also regular kind of like, you know, traditional health insurance Medi-Cal. So if you have $500,000 is actually a perfect, like $500,000 to $2 million is where we suggest see an attorney that has experience with Medi-Cal planning. And where it generally comes up is around long-term skilled nursing. Like, you know, you need it. Oh, wait, you have too much to qualify. But the way you do it is you actually, there's some trusts that you can set up, and you want to be strategic about it. Because even like, the thing you don't want to do is just rely on what you hear out there, because there's some talk out there like, oh, just spend down all your assets. And if you spend down all your assets, you might not be able to get into the place you want to get into, like for your long-term care. Often the long-term care facilities will only accept, like they'll accept more people who come in private pay than people already on Medi-Cal. So if there's a particular kind of condition or facility that you want to get into while you're private pay, at least 2 to 3, sometimes 6 months they require having that before you transition into being on Medi-Cal. So there's all these timing issues. There's all these kind of like, there's a way you can do it by making certain kinds of gifts in certain ways, but a similar kind of gift will disqualify you. So that is the complicated way to say this is a really good time to talk to a person who does Medi-Cal work.
Yeah,
I can do some of that, but if I'm not the right person, I know people who can do it.
maybe we can set up another part in this series. I think that would be really, probably very worthwhile. We are right about at time, so I think we can call it there. Thank you so much, Alma. This has been super informative. I want to encourage all of the people watching to visit. We've got Alma's website here. Reach out to her. She's obviously the expert. And then to also check out our website, glbthistory.org/legacy, where we'll post this video, some of the resources, and we'll have some suggested language people can use in their estate planning. And some other resources on there. So give it a check out, glbthistory.org/legacy. That should be posted up there soon. Thank you so much. This has been great.
Can I just add one more thing, Andrew? Is that the tax laws, there's a lot of talk about how the tax laws are likely to change if we have a regime, if and when we have a regime change. And a lot of the talk is that if you're thinking about large charitable giving, that this is the year to do it, because if there's a tax law change, there is precedent for having the tax law change go retroactive. Like if they pass something in December 2021, they can make it retroactive to January. So if you're thinking about like some kind of planned giving over a period of time with a charitable trust or whatnot, this would be the time to talk to your estate attorney so that they could help you with something before December. If you wait till November, it might be too late.
Good to know. I didn't know that. I hope everyone listening is paying attention. I'll be following up soon with more information.
All right. Thank you, Andrew, and thank you, everyone, for inviting me.
Thank you so much. Visit us online, glbthistory.org, for a lot more programming. And thank you so much for joining.
Take care.